CIR versus Filminera Resources Corporation, GR number 236325, September 16, 2020, facts of the case. Filminera Resources and Philippine Gold Processing and Refining Corporation entered into an ore sales and purchase agreement for the third and fourth quarters of the fiscal year ending June 30, 2010. Filminera Resources sales were all made to PGPRC. Filminera Resources filed administrative claims for refund or issuance of TCC of its unutilized input VAT attributable to its zero-rated sales for the third and fourth quarters. The CTA division denied Filminera Resources petitions on the ground of insufficiency of evidence. It held that Filminera Resources failed to prove that its sales to PGPRC during the third and fourth quarters of fiscal year 2010 qualify as export sales subject to the 0% rate under Section 106 of the 1997 National Internal Revenue Code, as amended by RA 9337 and Section 4.106-5A5 of Revenue Regulations number 162005. Filminera Resources sought reconsideration and submitted a certified true copy of BOI certification to establish that PGPRC was a BOI registered enterprise that exported its total sales volume from July 1, 2009 to June 30, 2010. The CIR counter-argued that the BOI certification failed to prove that all PGPRC's products from January 1, 2010 to June 30, 2010 were actually exported. CTA Division amended its decision on petitioner's motion for reconsideration. Considering that the validity period of the BOI certification covered the period subject of the claims for refund, the CTA Division concluded that Filminera Resources sales were zero-rated. The issue here is whether Filminera Resources Corporation is entitled to tax refund on its third and fourth quarter sales for fiscal year 2010 to PGPRC. The court ruled that no, Filminera Resources Corporation is not entitled to tax refund on its third and fourth quarter sales for fiscal year 2010 to PGPRC. The taxpayer claimant has the burden of proving the legal and factual basis of its claim for tax credit or refund. After all, tax refunds partake the nature of exemption from taxation and as such must be looked upon with disfavor. It is regarded as in derogation of the sovereign authority and should be construed in strictissimi juris against the person or entity claiming the exemption. The taxpayer who claims for exemption must justify his claim by the clearest grant of organic or statute law and should not be permitted to stand on vague implications. The burden of proof rests upon the taxpayer to establish by sufficient and competent evidence its entitlement to a claim for refund. Under Section 112A of the 1997 Revenue Code, the seller may claim a refund or tax credit for the input VAT attributable to its zero-rated sales subject to the following conditions. Number 1, the taxpayer is VAT registered. Number 2, the taxpayer is engaged in zero-rated or effectively zero-rated sales. Number 3, the claim must be filed within 2 years after the close of the taxable quarter when such sales were made. Number 4, the creditable input tax due or paid must be attributable to such sales, except the transitional input tax to the extent that such input tax has not been applied against the output tax. And number 5, in case of zero-rated sales under Section 106A and 106B and Section 108B, letter I, number 2, of the 1997 Revenue Code, the acceptable foreign currency exchange proceeds have been duly accounted for in accordance with the BSP rules and regulations. The first and third requisites have been established before the CTA. Filminera Resources is a VAT-registered taxpayer that filed administrative and judicial claims for refund within the period prescribed by law. Meanwhile, the fifth requisite is not applicable. As for the second requisite, Filminera Resources failed to prove that its sales to PGPRC for the third and fourth quarters of fiscal year 2010 are export sales. We reiterate that without the certification from the BOI attesting actual exportation by PGPRC of its entire products from January 1 to June 30, 2010, the sales made during that period are not zero-rated export sales. The second requisite not having been met, there is no need for us to discuss the fourth requirement. Filminera Resources is not entitled to a refund or the issuance of tax credit certificate in the amount of 101,579,541 pesos and 76 centavos, representing its unutilized input value added tax attributable to zero-rated sales for the third and fourth quarters of the fiscal year ending June 30, 2010.